Hi folks, and welcome back to Conveyancing. This is video 2 in the week 1 videos on ethics and such, and we'll jump back into the Prezi. And you will recall that in the first video we had a look at contracts, particularly the REIQ contract, your new best friend. We also had a look at solicitor's authority, particularly in relation to granting of indulgences and making choices where your client has an election. So now we'll cover off the last two topics, duties and ethics. So let's jump into duties. Look, there really is no rocket science in relation to a solicitor's duties. In relation to conveyancing, they're spelled out very clearly in the conveyancing protocol. As I said to you in the first video, it gives you really a blow-by-blow guide to exactly what you need to do and when. So very convenient. But principally your duty is to advise on the contract terms and also the risks inherent in those terms for your client. As the text says, you don't want to advise them on every single term because that would involve, much pulling out of hair, and it would cost them an awful lot of money, and you probably wouldn't get any repeat business. So you need to pick and choose what you advise your client on. Often, as I said in the very introductory video, the welcome video, when we were looking at the mind maps in terms of the steps of in the process of conveyancing, I said oftentimes you will only be instructed after the contract has been concluded and times have already started to tick at the time for example, building and pest inspection, the time for finance and so forth. So you need to get your head around those kinds of clauses fairly quickly. Any unusual terms that you can see, risks inherent in the terms, as I said to you, for your client. And sometimes you will be asked for advice before the contract has been concluded. You may get clients come to you and ask you to actually draft up a set of special conditions that will be annexed to the REIQ standard forms. This is fairly standard practice by purchasers of higher end property. They will often come to you and they'll have a very unique set of circumstances that they need you to document that will all form part of the sale, and you need to draft up a set of special conditions there. So that might be one circumstance where you are involved getting instructions prior to the actual contract being concluded between the parties, being actually executed. You need to, as the protocol says, keep an eye on the scope of your retainer because conveyancing is a very fluid beast, and what starts out as parties often being very convivial with each other and everything on good terms can quickly devolve to a situation of animosity where both parties back away and it becomes very adversarial very quickly. You may find that as a result of some of your searches and so forth, you find out information that show that perhaps the right disclosures haven't been made, and the nature of what has been revealed will require an extensive amount of extra work on your behalf. And at that point, you really need to revisit the scope of your retainer, keep the lines of communication open with your client, and make sure that if your retainer has to be revised, that you send out revised documents, because there's no point starting with a retainer that describes the work you're going to do in one set of terms, but really it blows out to something much, much more that's not actually covered by your original retainer, and therefore you can't charge for it. So always be mindful of those kinds of business-related aspects to the scope of your duties. Okay, so that's really all we need to say about solicitors' duties. Then, of course, we have the issue of ethics. Now, a lot of you, this being a later year elective, may have already done professional practice, legal professional practice. And in that subject, you will find great expositions on all of this kind of stuff. So if you've already done it, that's great. This will just be revision for you. If not, here are the salient points around ethics that you need to be aware of in terms of a conveyance. Firstly, it might sound silly, but the very basics. Get to know your client. You have to know who your client is before you can work out what ethical duties will flow from your business relationship with that client. Very, very important to verify their identity for a number of different reasons, not just ethical, for just the security of the transaction. Becomes particularly important where electronic transactions are involved and e-conveyancing. There's a whole wealth of hurdles that you have to get over. That was a bit of a mixed metaphor, wasn't it? There are many hurdles that you need to cross in terms of properly verifying your client's identity for e-conveyancing. So make sure that you're aware of those. We'll get to do electronic transactions in much more detail later in the unit. But particularly the Land Titles Practice Manual is located on Moodle. And that's very, very useful in terms of exactly what you need to do to make sure that you've verified your client's identity properly, and for things like being able to witness documents and so forth. So it might sound very basic, but something that you need to do. So the next thing we need to look at is the Legal Profession Act and the Solicitors Rules. And the Legal Profession Act 2007 allowed the Queensland Law Society to make rules for the Queensland legal profession. And what they've done is they have adopted the Australian Solicitors Conduct Rules. Those rules will bind all of us admitted practitioners here in Queensland, and we absolutely must comply with those rules. If we don't, there is every possibility that you can get struck off for misconduct. So they're not something to be trifled with. The main issue that we're going to look at for the purposes of this unit are conflicts. In particular, we're interested in conflicts between your duty towards your client and either your own personal interest or your competing duties. So we'll have a look at those in a little bit more detail. Firstly, a conflict between your duties towards your client and your own personal interest. Obviously, well, it apparently isn't obvious to some, but you can't act for a party in a matter in which you have a personal interest in which you may or may potentially conflict with your client. Essentially, you're bound to protect your client, and wherever there's going to be something that impedes your ability to do so, like your personal interest, then you have a duty to avoid that particular conflict situation. You'll see in the Australian Solicitors Conduct Rules 12.1, it's not just your own personal interest, but it extends to associates of you as well, so your family and so forth. So anywhere where you have a personal stake in the matter, you shouldn't be acting. Simple as that. The other area is the conflict of duty towards your client and your duties towards others that may butt up against the duty to your client. Concurrent duties is the problem here, and acting for more than one party in a transaction. Look, I'd skip everything and go straight down to the type that I've put in bold down the bottom. If you're ever in doubt, don't act. As I said, you know, whilst there's no blanket rule against this, and you can do it if everybody knows what you're doing and everyone's given informed consent. The nature of conveyancing is a very fluid situation, and what can seem like a very friendly scenario to start with very rapidly can change. And when it does change, you will find yourself right in the middle of that, and you'll be in all sorts of bother. And if I needed to hammer the point home, which I probably don't because you're all very sensible people, we'll just have a quick look at the case of Mantinella. Okay, so in this case, poor old Mr. Thompson was an unsuspecting solicitor in Cairns, happily acting for an estate, and this estate wanted to sell its business, which was a going concern called Royce's Restaurant. And to sell the business, they needed to sell obviously all the goods and chattels of the business, as well as possession of the premises, which were a leased premises. So the estate had to procure assignment of its lease of the premises to the new purchaser. The incoming purchaser was very, very keen to get things done, asked Thompson to represent him. Things seemed to be fine between the parties. In fact, the purchaser, it says Mantinella there, but the original purchaser was a company called Freeway. Mantinella was the follow-up company that Freeway morphed into partly along the way. Jorgensen was the director that was involved in all of this conduct here, and he was very, very keen to get the job done. He really wanted this restaurant, and asked Mr. Thompson to represent him. As I said, everything seemed to be going swimmingly. So Thompson said yes, and there is the fateful problem. Ultimately, the deal fell apart, turned very ugly, and Mantinella lost money because the landlord wouldn't assign the lease. And so what do you do when you're a purchaser and you've been pipped at the post and you've lost some money, and you're not happy with the way things have gone? You look very carefully at what the solicitor working for you has done. You go and visit a new solicitor, and then that solicitor says to you, conflict of interest here, why don't you sue the old solicitor? And so poor old Mr. Thompson found himself in the hot seat. And when I say hot seat, I'm not kidding. The purchaser alleged that Thompson failed to advise the purchaser that he needed to provide a specific $25,000 performance bond to the lessor. He said he didn't get advice about that he needed the lessor's consent to assignment of the lease. He alleged that he didn't get advice that he shouldn't pay the rest of the purchase price until the lease had been assigned. He alleged he didn't get advice that basically that he should have gone and got himself some independent advice. So there was a whole series of very unfortunate events. Essentially, it all boiled down to the fact, as I said, that the lessor didn't want to assign the lease unless the incoming lessee could show that he was of good standing and was financially able to take on the lease and make a go of the business. Hence, he needed this performance guarantee, the bond. The buyer was having trouble coming up with the money for the bond, and then everyone seemed to have gotten very confused about when settlement was going to be. This very keen purchaser got his hands on possession of the property and possession of the chattels as well. He defaults in a number of ways, and the lessor just gets very fed up and terminates. So then there's this case for the purchaser decides to sue the landlord for forfeiture to recover possession of the property, and he won that particular case. But then things still had to be resolved in terms of where the purchaser was at in the whole transaction. And he lost out at the end of the day, obviously, because there was no effective assignment of the lease to him or to the company. So, as I said, he turned to his new lawyer, who's pointed the finger at the old lawyer, as is usually the way, and a outcry of breach of fiduciary duty was made. There was certainly a breach of fiduciary duty at the point where, as I said, there was this confusion over the settlement date. The solicitor ended up taking the purchase money that the purchaser had put into his trust account and transferred it over to the seller, the estate, and at that point put himself in a very clear position of conflict of interest, because what he's saying is that basically the estate is entitled to get this money, and the purchaser certainly thought otherwise. So he would have gone down in flames if it wasn't for the rather irritating and peculiar nature of Mr. Jorgensen, this director for Mantinella, who really didn't leave a very good impression on the court at all. And because he had been very, very persistent, even belligerent in his handling of this particular transaction, and had basically pushed his way in, the court said, well, look, there were some things that they could pick up on in the evidence that showed that the allegations that he hadn't been advised about the performance bond, he hadn't been advised that he needed to get the lease assigned to him, that he shouldn't pay over his purchase money until the lease had been assigned. All those things, they found that there was sufficient advice on those matters. Nevertheless, there was a clear position of conflict here, certainly at the time when Thompson transferred over that purchase price from the purchaser to the seller, the estate. So he would have gone down in flames, if not for the fact that because of the buyer's personality here, they held that he had been fully informed of the nature of this transaction and that Thompson was acting for both parties, and that he had actually given his consent. So, salient lesson there, even where you think that the matter is going to be quite a simple one, don't underestimate the ability of these things to go pear-shaped, and don't find yourself in the sad position of Mr. Thompson from Cairns. He did escape paying out any damages, not only because the purchaser had been fully informed and consented, but also because there was found to be no causation between the purchaser's losses and Mr. Thompson's conduct, because the buyer here was just so belligerent and forceful in pushing the deal through. So that basically severed the chain of causation between Thompson's breach of fiduciary duty and the loss that was suffered. So, salient lesson. Poor old Mr. Thompson from Cairns, as I said, don't find yourself in that position. And that is conflicts. And now the only other thing that we need to touch on for today is undertakings. And I'm sure, as I said, if you've done legal professional practice, you'll know all about undertakings. But they are a very solemn affair, and it's essentially a promise that you will do something that you've said you will do, used by solicitors in their professional capacity, and very, very important that they are upheld. A common one in the conveyancing scenario is where the seller delivers the very valuable signed transfer document across to the buyer's solicitor, and in those circumstances you certainly want an undertaking about what's going to be done with that document before settlement. So you're going to undertake to receive the signed transfer documents for the purposes of stamping, for example. These are the kinds of promises that the seller will want to have so that they can enforce them if something goes wrong. Okay, so the Australian Solicitors Conduct Rule 6 sets out the requirements in relation to undertakings. And as you can see there, I've set them out in full because they're very, very, very important. So if you've given an undertaking, you must honour that undertaking and ensure the timely and effective performance of the undertaking unless you have been released by the recipient or a court. Okay, you must not seek from another solicitor or anyone associated with them undertakings in respect of a matter that would require the cooperation of a third party who is not a party to the undertaking. I'm hoping you're thinking privity here. Yes, indeed, folks. You can't make your undertaking contingent on what someone else is going to do that might have a real impact on what the subject matter of the undertaking. Okay, you must ensure that the undertaking is effective to do what it says it will do and provide the comfort it is intended to provide. So that is undertakings. You'll need to give them. They're not terribly scary because they're usual practice in conveyancing, and as long as you're prepared to do the right thing and honour them, there's really no problem. So that's undertakings, and that is week 1, contracts, solicitors authority, duty and ethics. And if you have any queries or questions, please chat with me in the Zoom, chat on Microsoft Teams, email me, tweet me, send me a message on Facebook. But I hope that we can chat sometime soon. I hope to catch up with you in the tutorial Zoom this week. If not, the recordings will be up on Moodle for you. So have a great week, folks, and bye for now.